of the most common problems we work with here at Redefined Horizons is a situation you get where your physical access to a piece of property doesn't match the legal access or right of way to the property. I would say of the expert witness work that we do, that's maybe 80%, which is a huge proportion. So this is a really common problem in real estate, and we find it a lot. It's a messy problem, and it's expensive to fix. So what I want to do today is I want to explain to folks that are in the land development business or the real estate business. I want to just explain to them what is this problem? I'm going to describe it, the different elements. Why does it happen? And how do you fix it? And what does it cost to fix? And how do you avoid putting yourself in a situation where you don't have legal access to a piece of property? Because that's a problem. All right, so let's define a couple terms. When we say legal access to a property, what do we mean? Legal access is the location and type of right-of-way you have been granted over the property of others to get to your piece. Now you notice that definition has two parts. It's the location, width and alignment, and the type. Type is also important. We more frequently deal with problems that have to do with the location and width, but sometimes types can be a problem too. So right-of-ways can be overburdened. So if you've got a 10-foot footpath, you may not be able to drive 200 sand and gravel trucks a day up that same 10-foot right-of-way. That's called overburdening, and it's an issue all the time in California. I just talked to an attorney a few weeks ago about a situation over in Napa County where a vineyard was trying to add on. They were trying to expand the capacity of the vineyard, and it was going to result in some more truck traffic. And they were fighting with one of the neighbors over how many trucks they could run up and down the private access easement. So it could be a problem, and it happens. The second thing we need to define is physical access. So when we say the legal access doesn't match the physical access, what do we mean by physical access? That's how you physically get to the property. So where's the road at? Where's the location physically on the ground? And what type of access is it, right? Is it a train track? Is it a trail? Is it a paved road? So what type of access and where is it on the ground? Okay, is it at the bottom of the gully? Is it at the top of the ridge? Is it a switchback road up the side of a hill? All those things could be important. All right, so what happens? Why do we get into a problem? Frequently, what happens is the legal right-of-way, so the access easement or even sometimes a public road, doesn't line up on top of the physical access of the road. So there's a mismatch. And I'll give you an example. This is an expert witness case I worked on a couple years ago. There was a half a dozen properties in the Bay Area. It was in the hill country there in the Bay Area, and all these properties accessed their homes through this little windy road that basically snaked back and forth on the top of a really narrow ridge. And in the old days they weren't super careful surveyors, and there was a deeded easement for all these. Each home had a deeded easement, and I just didn't land on the top of the ridge. Some places it was kind of half and half, and other places the physical easement was completely off the ridge top. And the document it didn't have the controlling calls we needed. That's what it's a surveying term to reasonably interpret that the easement was on the road, and the neighbors were fighting over it. And so the attorneys came to me and the title company said, "What do we do?" I said, "You got a problem. We got to either move the physical road or we got to move the access easement." And in this case, we couldn't move the physical road. It was on the top of a ridge. There was nowhere to move the road. So we had to help them. Abandon and then acquire new easements over the actual physical road. So that's one example of how this happens. I've got another example. Again, this is a hilltop lot in the Bay Area, and this property had a deeded access easement to a public road on the west side. But when you actually go out, so it looks great on paper. Like you look on the tax assessor map, you're like, there it is. That's how they get to the public road. But when you go out and looked at the property, it was a 1-to-1, somewhere between a 1-to-1 to 2-to-1 slope. And there's a little spot at the top where you could build a house, and the rest of it was just super steep. And I don't want to say it was impossible to get a road down that slope to the public road, but it would be an engineering feat. Like I'm talking about, retaining walls and suspension bridges, and it would be crazy. And you might be able to do it, but it'd be really expensive. So the actual physical access was up at the top of the hill. They had a driveway and they were driving in and out to another quasi-public road, we'll call it. And they didn't have legal rights over that. And they got in a fight. They came in to build their dream house at the top of the hill, and they got in a fight with a neighbor. So that's another example where the physical access didn't match the legal access. So how do you solve these problems? Now we understand what the problem is. How do you solve it? As I mentioned, there's two things you can do. This is what I told the title company. Move the physical access, or you move the legal access. Those are your two choices. I dealt with another case, helping an attorney just a couple weeks ago. Bought some ag land over in the East Bay, big parcel, a couple 100 acres, and there was a physical road that didn't fall in the easement, and they were trying to figure out what to do. And in this particular case, it was probably cheaper to move the road, to build a new road. I told the client, you probably want to build a new road here. Fairly simple. It was a short stretch and it was flat. I said it's probably going to be cheaper than fighting the neighbor in court. So those are your two choices. Move the physical road or move the legal right of way. So how much does that cost? Well, it's like a lot of things. It depends. The cost could very well exceed the value of the parcel. I have worked on cases where the value to fix the access to the parcel costs more than the buyer paid for the parcel. And that's no bueno. That's no good. So it can be very expensive. Usually, this isn't always the case, but usually, as a rule of thumb, designing and constructing a new physical road is typically more expensive than moving the right of way. So when you're gonna move a physical road, there's your design costs and your construction costs, plus you have permitting costs in California. So in a lot of cases, more expensive to move the physical road. But obtaining a legal access over the existing road is, although it's usually less expensive, that doesn't mean it's cheap, and it's definitely not free. There's still significant costs there. You got to pay for a survey, boundary survey, a topo survey. You got to go in and create easement packages for each property that you impact. If you're smart, you'll monument that right away so these problems don't happen again. So it could be tens of thousands of dollars to do that. If it's just a little stretch over one parcel, maybe it's a few $1,000s. If you got a long stretch over several parcels and it's in an older area that hasn't been surveyed in a long time, it can be very expensive. So what does this mean if you're a real estate developer or a real estate investor? What does that mean for you? Number one, don't assume your legal access matches your physical access, and don't take your broker's word for it either. A lot of times the real estate brokers say, oh yeah, here's how you access the back half of your property, or yeah, you use this trail to get over the ridge, or you need it in writing. And what you really need is an easement and a map that shows where the easement is in relation to the ground. Do not take your broker's word for it. I've had more than one case where people ended up in a lawsuit because they took their broker's word about access, and the broker didn't know what they were talking about. I'm not knocking brokers, but brokers aren't surveyors, and you got to be careful. And if you're a broker and you're watching this, don't make assertions about legal access and physical access to a property to your client if you don't know what you're talking about, because it could get you into trouble and it can really hurt your client. So don't make assumptions. Don't assume just because there's a physical road there that that's where your legal access is. Number two, investigate the means of physical and legal access to your parcel. So do your homework, do your due diligence. Do you have an access easement? Does your parcel touch a public road? Do you have access onto and off of that public road? Sometimes your parcel's on a public road, but it's restricted access. You can't put a driveway in, even if you wanted to. We see that all the time, especially with highways and freeways. So you need to investigate that. And then you need to understand the legal access to your parcel too, not just the physical access. So I've got 4 questions you should ask about legal access or right of way to your parcel. This is before you buy. Ask these 4 questions about legal access. Number 1, where is the legal access located? Where is it located on the ground? Number 2, is the right of way marked? Can you find it? Number 3, what type of access rights do you have? Is that a public road? Is it a private road? Who can use it? Is it exclusive, or can multiple parties use it? What type of access does it give you? Is it 2 vehicle trips a day or 100 vehicle trips a day? Can you run commercial traffic up and down it? Does it cover the existing use? Does it cover your intended uses if you're going to develop? You need to ask those questions. Here they are again, the 4 questions. Where is your legal access located? On the ground. Is it marked? Is it monumented? What type of access rights do you have? And does it cover the existing or intended uses? So if you're not sure about any of those 4 questions, or you're not sure about the physical access that you have, get help from a land surveyor. Do that before you buy. Don't get burned. Don't be like all these other people I deal with. 80% of my expert witness cases when I'm working with land attorneys are because there was a mismatch between the legal access to a property and the physical access to a property. Don't put yourself in that situation.